Good morning, everybody. Welcome to our DMH webinar this morning. Thank you very much for joining us on the first morning of lockdown Mark II. We're very honoured to have you spending time with us. Bonfire night as well, but I think the celebrations for that are obviously going to be slightly muted. So I'm afraid I think the excitement of your day is going to be myself and my colleague Adam Williams trying to help you not to lose an employment tribunal claim. And this morning's webinar is the first in 3 webinars that we are going to be doing over the next few weeks to try and help you not to lose your employment tribunal claim. Some of the employment tribunal statistics that have recently come out are quite alarming. So we've only got statistics up to the end of June at the moment, but for April to June 2020, the rise in claims was 18%, and perhaps more worrying, the rise in actual outstanding caseload at the tribunal was 31%. Those figures are obviously going to increase because of rising levels of unemployment that we're seeing, and also changes to working conditions, which are creating a whole raft of disputes. So we would actually quite like to keep you out of the tribunal, and that's probably the best way of not losing an employment tribunal claim. So our session this morning is about how you can have some discussions with your employees in terms of resolving disputes. So those will be things such as off-the-record conversations, without prejudice conversations, protected termination conversations and negotiations, and the differences in respect of those sorts of conversations. I'll be looking, after Adam has worked through the protected conversation points, I'll be looking at the issues with regards to documents, confidential and privileged documents, and what might need to be disclosed in a tribunal setting, and what documents won't, because they may well attract what we call privilege in the tribunal. So before I start, I also just want to make a very passing comment about our favourite subject, furlough. Just to let you all know that you've got 50 or 55 minutes free of furlough. We're not actually going to be mentioning anything about it today. We're still waiting for the government to put more detail out about the latest extended furlough scheme. And when that happens, we'll be putting some information out to you on that. So furlough free zone this morning for you. As normal with our webinars, please use the Q&A function if you've got any questions on the session. But with that, I'm going to hand over to Adam to talk you through protected conversations. Thanks, Adam.
Thanks, Rebecca. Good morning, everybody. Pleased to see a big number of people on the call today and weren't put off too much by the title. Yes, as Rebecca said, we've seen a big increase in tribunal claim numbers. It seems to be a trend now, and also the period of time it's taking for claims to be processed, as Rebecca said. So I'm going to pick up the first broadly half of the session today around conversations you might be looking to have with employees with a view to reaching an agreed position, typically on their departure from the organisation. And before we do that, if we can just take a quick poll. The poll is, have you had a pre-termination negotiation meeting in the last 6 months? So that would include any form of discussion with employees that you've had with a view to reaching some agreement for departure, where you're intending that discussion wouldn't be disclosable later. It's a yes, no one. And so here's the results. And yes, the 38% said yes, 62% said no. So quite a large number of you overall have had one of those discussions in the last 6 months. So it'll be quite interesting for us to see and compare how those 2 conversations went when you see what we're going to be talking about today on the topic. So if we move to the session itself, let's talk about the different types of conversation that you might have in this context. and the differences between them. And what we're going to look at is three broad areas or types of discussion or labels that might apply. There's the off the record conversation. We're really familiar with that sort of language and expression. There's also the without prejudice conversation, and there's the pre-termination negotiation. So let's just look a little bit more in more detail in each of those and get in our minds the key differences between them. So off the record, that's common language, as I said. It's something that's used probably most regularly out of the three, and it's an unofficial understanding, is the way I would describe it, that a conversation you're having with someone isn't to be recorded or to be disclosed to others later. Big problem with off the record in this context is that it actually has no meaning at all and confers no protection at law. Whether or not you've both agreed it's off the record or not, it can later be used in litigation and proceedings, unless you've also ensured that it's not only an off the record conversation, it's also a valid pre-termination negotiation or without prejudice discussion where there is protection for the relevant proceedings on top. But if you're just purely having a discussion on an off the record basis, there isn't any protection there. It doesn't mean that it might never be the appropriate route. In some limited circumstances, you could see where, particularly if you're not actually that concerned about the nature and content of discussion coming out later in proceedings, you might prefer to use that more informal approach because you're quite relaxed about the information coming out. But if there's any desire to ensure that the discussion is not disclosable later in proceedings, this is not the route to go. So that's the off the record. Without prejudice, this is a long-standing common law principle. So it's derived from the case law and development of law through the courts. And it's one of public policy, essentially. It's a means by which to have a discussion with a view to settling an existing or anticipated legal proceedings or dispute in circumstances where what you say in those discussions can't be used against you later. So your discussions will not prejudice your position in subsequent proceedings because they'll be confidential. That's hence the without prejudice label to this one. The public policy reason is, of course, that if no two potential parties to proceedings could have a discussion about resolving them without the threat of what they say being used against them later in court, the courts would have a much greater number of cases to deal with because nobody would feel able, or lots of people would feel unable, to have a conversation about settlement for fear of it being used against them. A couple of key factors in relation to without prejudice is it's a protection that applies where there's a genuine attempt to settle an existing dispute that might be put before the court. So two key things there: genuine attempt to settle and existing dispute. So that's without prejudice. What if there's no dispute? You've got a poor performer, breakdown in relationship. That's a fact-specific issue, and sometimes it's not that easy to absolutely nail down. You might have a grievance. That in and of itself may not amount to a qualifying dispute from which you have the protection, if you use it, of without prejudice confidentiality, because there actually may be no disagreement over the facts of the grievance. It's relatively unusual, I'm sure, for most people watching today for this to be the case, but it may be that you say, no, we agree with everything you said in your grievance. Disciplinary might be no sanction imposed, no further action, and therefore unless the person takes issue and you end up in a dispute as to whether you as employer had any right or legitimate basis to even follow the process, query whether there's a dispute. Relationship breakdown, even then the employee may be blissfully unaware that the employer feels the relationship is breaking down as is becoming untenable, and so they will say, well, I'm not at this point in any dispute with you. You won't have the protection. You can seek to use the labeling and hope that everybody will behave as if it does apply without prejudice, but you won't formally actually have the protection of without prejudice without that dispute being clearly identified. You can also lose the protection if you behave very badly. The common law rule is if you act in a way that involves unambiguous impropriety, which is another way of saying being very bad indeed, that you can lose the protection. Or if actually there's no genuine attempt to settle, if you're just saying, can we have a without prejudice conversation in order to threaten the individual or tell them that this and this is going to happen to them unless they just leave, that's not a genuine attempt to settle, that's an attempt to bully someone out of the organisation, you won't be protected. For both reasons. It's probably unambiguous impropriety, the way I described it, and you're not actually trying to settle anything. It's important to take care in the language used, even if you've got what you're confident is a without prejudice discussion. Take care about the language used. Put it in the context usually of exploring options. This is one option, there's others here. I say that mainly because, well, firstly, there is always the risk that you haven't actually got without prejudice protection, or it's later lost. Or, and more generally as applicable, that even if without prejudice protection applies so that the courts are not entitled to see and hear what's discussed, whatever you say will be placed in the mind of the individual and can set or alter their path in a way that it doesn't matter whether the tribunal can see or hear about it later, it's influenced your relationship with them and what happens next. By that I mean, if you say something in the without prejudice discussion that offends them, sets them off on the wrong footing, or entrenches them in a position because it doesn't go well, it doesn't matter that they can't tell the tribunal or court that. It may just mean they're going to follow a path with you that we can't row back from. So it's always about knowing the audience when you're having these conversations and knowing how they might decide in their own mind to behave towards you or proceed based on what you tell them. So that's an extra bit there about without prejudice. Third area we're looking at is the pre-termination negotiation. And that is, unlike the common law rule around without prejudice, that is a statutory provision and a framework introduced in 2013 to essentially expand out and create another forum through which you might be able to have a confidential discussion with employees without it being used or disclosable later in tribunal claims. And the key distinction and potential benefit of a pre-termination negotiation as compared to without prejudice is there is no need for an existing dispute. So you don't have to think about, are we in a dispute here that could reasonably be seen as possibly leading to litigation, all that sort of stuff. There's no need for an existing dispute. And notwithstanding that, the fact and content of the discussions won't be admissible in tribunal claims, but only certain claims. And we'll come on to that through the case study as well. It's also distinct from without prejudice, though, in that there's a much more prescribed process that has to be followed in order for you to have the protection. There's a code of practice that sets out the steps that have to be followed and also comments on how settlement agreements should be presented and then negotiated and agreed off the back of these discussions. But you have to follow some pretty prescriptive steps, and some elements of those requirements may not be that palatable or attractive, and you have to take a view on whether you're going to still treat it as a pre-termination negotiation, notwithstanding you're not going to follow every step to the letter, or try a different route. There's also a supplementary guide, but it's only the code of practice that is actually binding on tribunals when looking at whether the protection of a PTN applies. We're just moving forward to the next one. Some practical issues with pre-termination negotiations. Well, this also applies in without prejudice discussions as well, I think. How and when would you initiate the discussion? Who broaches the subject of reaching an agreement first? And I think the timing and dynamics of that are very important. The context in which either party broaches this sort of subject can be indicative to the other party as to their position, their feeling of exposure, and therefore create a greater level of expectation around, if you're the employee, what you might get in settlement. I'll give you an example. If you go through a disciplinary process with an employee, end up in a position where you find there's no further action required, no case to answer, that might not be a great time to then go to the individual and say, shall we have a pre-termination negotiation about your departure? Because the individual will feel, well, why are you asking me that now? You've just gone through a process and have no basis to sanction me, and therefore feels in a strong position to either reject that discussion or have some quite high demands. Contrast that with being at the front end of a disciplinary process where the position looks potentially very bad for the employee because of the facts on the face of it that are going to be investigated, and the outcome could be bad for them. That might be a better juncture at which to say there is another route here, if all other things fall into place and make you feel that's the right thing to do. It's important to give the PTN as one option only, I think. Rarely is it a good idea to try and force someone into a PTN. It does need to be through consent, really. and the individual needs to understand what the PTN is, and needs to have that explained to them. Having said that, invariably I find, and I don't know, I think Rebecca maybe does as well, that in vast majority of cases, if you explain what a PTN is in the right way and to tell the employee that you have a proposal to make, most employees will be inquisitive and will agree because they want to hear what that proposal is. One little tweak or issue in the ACAS code is around the right to be accompanied in these discussions. And that's one of those examples of an area where you may look at it and think that's just a requirement of the code that we don't want or don't feel we should comply with, having an accompanying person of their choice sitting on a discussion where we're proposing financial offers to them for departure. A careful decision needs to be made about whether you still follow a PTN but don't follow that part and risk losing the protection, or you take a different route. Of course, the different route, the obvious one being WP or without prejudice, you get the issue of, is there a dispute on that? There are other requirements like giving 10 days to consider the offer, which all form part of that prescriptive approach. But the key point around pre-termination negotiations in terms of risk is that they only provide you with protection in subsequent proceedings in respect of an unfair dismissal claim. And I think, therefore, a very important takeaway is that in terms of the protection, employers need to think very carefully about whether that is, in fact, the only obvious claim that the individual might have or seek to bring. Because if they bring a different claim, for example, discrimination, the pre-termination negotiation will not be privileged and confidential in respect of that claim. So it's absolutely important, probably even more so with PTNs as compared to without prejudice, to assess the individual's position and what they might try to bring later in terms of proceedings. So just moving on to the next slide. There's a broad framework in which you can use PTNs. That could be in a misconduct, capability, or redundancy context. Pretty rare to use PTNs in redundancy context. Often it's through a voluntary redundancy program, but possible in theory. Probably you can also do it in SOSR dismissal cases where there's no particularly obvious other reason or potentially fair reason to dismiss that's looming down the track, but nonetheless we feel that the relationship has become untenable, or there are other reasons like reputational damage or whatever that make us want to have a conversation. The important thing there is obviously carefully articulating why you're having the discussion. And one key factor in pre-termination negotiations is around improper behavior. You'll see at the bottom of the slide there. And a key facet of that is it's important that you're not saying to someone, you are going to be dismissed at a later date. So let's agree something in the alternative. It must only be a possibility. You have to come into this conversation on the basis, look, there are circumstances X, Y, and Z. It means that a process has to be followed or a discussion is going to be had, and it could result in us looking at terminating your employment. Underline could. We'd like to have a conversation with you about whether there's any other options that would be agreeable to both parties on that. We talked at the last slide, preempted this point around protection is lost, or in fact is not actually available at all where the proceedings are discrimination or whistleblowing or anything other than unfair dismissal. And the improper behavior point, we talked about telling someone, well, you're going to be dismissed if you don't do a deal. That's one example, but there's general rules in the code around improper behavior. Don't intimidate, don't put undue pressure on the individual. And that is a lower hurdle for an employee to get to than without prejudice, where it's unambiguous impropriety. That's quite a high standard of bad conduct for you to lose the protection. Here, it's at a lesser degree. Undue pressure could, of course, arguably take many forms and not necessarily be particularly terrible behavior. And there's clearly scope for debate and argument around whether undue pressure was placed and therefore the protection is lost. So it has a place, pre-termination negotiations, but it's more prescriptive in how you deal with it. It's narrower in terms of the protection it affords for proceedings, and there is a greater emphasis on behaving properly. So we are now going to make an attempt, Rebecca and I, at some amateur dramatics for you. So bear with us and do some case studies around this discussion, just to flesh out some of the points that we've been through there. And we're going to start with a scenario where I will be playing the role of the HR manager or manager, and Rebecca has kindly agreed to be the employee in this. So we'll walk through the case study. It's not very long, but it's an attempted discussion by me with my employee to see if I can short circuit a situation and get to some form of agreement. On your slide there, you'll see some of the takeaway points around the three types of discussion that we've talked about, and that may be helpful to look at whilst we go through the case study, and then we'll reflect at the end of the two on the learning points. And Rebecca will play manager and I'll be employee on the second one. So here's the first of our case studies. Hello, Rebecca. Thanks for coming in and attending the meeting today.
Hi, Adam.
I need to have a discussion with you and follow up on our discussions last week about your unsuccessful flexible working application.
Yeah, pretty disappointing.
Yeah, no, I understand that. And the recent reduction in work we've had whilst you've been on maternity leave, unfortunately, those things just happen to have coincided while there's just been a surprise. Yeah, it's very unfortunate. But it's really due to COVID. It's nothing to do with the fact you've been on maternity leave. It's just COVID. And I'm afraid that does mean that it might result in your redundancy. I'd like to be able to find out from you today what your preferred outcome from our discussions are, and try to enable us to have an open discussion about and one that you're comfortable with on a without prejudice basis. Our conversation will be what's known as a sort of protected conversation, and that means that what we talk about today and any follow-up discussions on it can't be referred to if there's any subsequent discussions internally about your role or any external legal proceedings. Not that I think there's any prospect of legal proceedings, of course, but just as a formality, that's what this is.
That sounds a little bit formal. Do you think I should bring somebody into the meeting with me?
Oh, no, nothing like that. It's not particularly formal, but I just have to obviously cover off certain points and just explain that it would be a discussion that we won't be able to refer to later if there was any dispute or formal discussions around the redundancy process, etc. Are you okay to have that discussion? I just want to set out for you where we're at and what we're thinking we might.
Well, I'm not sure. I mean, the redundancy is a bit of a shock, obviously.
Yeah.
I thought I'd be coming back next week. Well, I suppose I might as well hear what you've got to say.
Yeah, I mean, nothing's set in stone on that side of things just yet. I appreciate it's a shock, but yeah, good. Okay, so you're all happy. Great. Now, as you're aware, customers' calls in terms of our call centre handling have reduced substantially due to COVID and the impact on the sector and the economic climate. And what work we've had has been picked up by the call centre manager during your maternity leave. And we've had to take some difficult decisions about, because of the pandemic and uncertainty, about how the business might run. And we don't know when business as usual might be resumed. And that's caused us to very carefully consider how we approach viability of roles. And we tried to contact you about this impact and your return to work plans in June, but couldn't reach you, unfortunately.
Not sure.
Oh yeah, we did.
No, not had anything from you at all.
No, I'm sure we did. Yeah. Okay, well, we'll look back at that. Most people have already been involved in a redundancy consultation, just so you know. But we decided to wait until now for you because we couldn't get hold of you. So didn't want to put you at risk, didn't want to worry you during your maternity leave, of course. And we hoped we'd find a new role designed to suit a flexible working hours arrangement of 8 hours a week. 8 hours a week. But what you've said, obviously, is that 8 hours a week doesn't work for you. And I get that. But the problem is your role doesn't have sufficient work to sustain a standalone role for you. It's just not enough work then. So we've got to make a decision on where to go. Now, one option is to place you at risk of redundancy and proceed with the consultation. And the outcome of that is not set in stone yet. But of course, there are these big issues around not having enough work for a standalone role. And we can still look at alternative roles during that consultation. But the other option that I wanted us to just discuss today is whether you want to consider an exit arrangement now. And we'd be able to put forward a financial package on similar terms to that which we offered others involved in redundancy consultation. It would require you enter into a settlement agreement if you decided on it, but it would be a financial package. Can I just outline for you what the broad sort of terms of that would be?
Well, you can, but I'm not taking much in at the moment.
Okay, all right. Well, maybe we can have a further discussion now once you've, if I say what I need to say now, and then we can speak again. So it would essentially be you would leave on an agreed date, relatively near future. You'd get payment in lieu of notice. You'd get any accrued untaken holiday. I know you've got some carried over through maternity leave, and you'd get an amount equal to 1 month's gross pay for each complete year you've worked. I think you've worked 3 years, or you're coming up for 3 years, and that would be uncapped. The statutory redundancy pay stuff has a cap on it, but that would be a full month's gross pay for each year worked. We think that's really generous. Hopefully you like the sound of that as well. But I don't expect you to make a decision today, other than to let me know if you're interested in exploring that more fully. And if so, I can arrange a further meeting, maybe for the end of this week, early next. I am aware you've got your return to work date, haven't you, imminently?
Yeah, next Monday.
Yeah, so it'd be good if you can let me know by tomorrow, please, if you're happy to have a further discussion. We have another without prejudice discussion, and then we sign a settlement agreement in the next 5 days. That'd be great. In the meantime, can deal with any queries you have, but I'm guessing you won't have any right now. You'll go away and reflect on it.
Well, I think I've got to go away and reflect on it, but yeah, it all seems a bit rushed, really, doesn't it? But hey, thanks, Adam.
Good. Well, I feel like that went really well. So great. Objective achieved. Go away, have a think about it, come back to me. Thanks.
Right. So end of role play, and let's just analyze what happened here. So Adam probably thinks he's had quite a successful protected conversation, pre-termination negotiation. I think the key issue here is it probably doesn't fall within the protected scope, because there is an element of discrimination that's likely to arise in this case. So fundamentally, the employee, so I haven't been consulted with whilst I've been on maternity leave in the same way as others. So there's a potential discrimination angle there. There's a potential discrimination angle possibly around the flexible working application that I put in. There could be an indirect discrimination, sex discrimination claim there. There are potential issues that if it was a protected conversation, maybe Adam should have been a little bit more robust in my right to be accompanied, a little bit less dismissive, perhaps, of just, getting on with it and creating a positive spin to it. Although, we all appreciate the challenges that, you have as HR. You're not going to create a negative spin on a protected conversation, but certainly, Adam perhaps, didn't need to be quite as dismissive of some of the issues. All feels a little bit rushed in terms of, let me know now, let me know sort of by the end of the week. Remember the ACAS 10-day recommended period of time that the employee should be given. There's also an issue if it's not a pre-termination negotiation and it's not protected in that way. Could Adam then say perhaps it was a without prejudice conversation, which a lot of employers will try if they lose the scope of the pre-termination negotiation protection. Now, I think the problem with this being a without prejudice discussion is there is not necessarily an existing dispute. Yes, there was an unsuccessful flexible working application, but it may well have been that I haven't put an appeal in yet. So it may well have been that I've just accepted that flexible working application was unsuccessful. So there could be an issue here that it's neither a without prejudice conversation because of no pre-existing dispute, and it also doesn't fall within the guise of a pre-termination negotiation, even though it was effectively to deal with redundancy, but that redundancy was tainted with a potential discrimination claim as well. So they're not always straightforward, and you've got to be really careful when you're using them to understand whether it is going to be something that is inadmissible in later proceedings. And what I would say is that, lawyers are getting quite cute now at challenging when a pre-termination negotiation has actually been a pre-termination negotiation. So we are finding quite a lot of lawyers, squabbling over whether something should be given that cloak of protection or not. Okay, we're going to go back into our role plays, but this time I will be the HR manager. Adam will be the employee, and this one is around a performance issue with an employee. Adam will do the analysis at the end of this. So we'll kick off onto our next script of a conversation trying to settle an issue. So morning, Adam. Thanks for attending the meeting.
No problem. You okay? Everything all right?
Yeah, all good with me. Well, actually not that brilliant, to be honest with you, but that's partly because, I need to have a discussion with you about the future of your employment. I think you know what I'm probably going to say, don't you?
No, but okay.
No? Okay. Well, I don't think you have actually been performing that well for a while. I mean, you didn't get a bonus in March, so there must have been some clues ahead that your performance wasn't necessarily, top notch this year. But a little bit surprised that you haven't realised the writing's probably been on the wall for this conversation for some time.
I thought that bonuses were stopped to prepare for COVID, the impact of COVID, but okay.
Well, no, some people have got it. Look, Adam, this is really difficult for me. I've been dreading this call all week, but, let's get on with it anyway. So the purpose of the meeting is, it's to discuss the potential impact of your poor performance and whether we're going to continue to employ you. Let's have the rest of this conversation on a without prejudice basis, shall we? So that means that anything that we're going to discuss, we're going to have it off the record. So if you do decide to take some legal proceedings in the future against us, then, I'm sorry, but you're not going to be able to refer to this conversation. But at least it means that we can speak more openly now, and hopefully, we can come up with a fairly quick, amicable solution. So, that all sounds probably the best way forward. So what I'm going to propose, Adam, is that you leave, you enter into a settlement agreement, because otherwise the reality is that we're all going to have to go through the pain of a performance improvement plan. And I'm pretty sure we all know how that's going to end up. So probably not a nice position for you to be in, Adam. So we're trying to save you that pain. We really don't want you to go through that performance improvement plan. So we've put a proposal together. Here's the settlement agreement. So, here's your 25-page document. Not much in it, really. So have a quick scan through. So
now.
Shall we just run through it together? So page 2. Yep. So your employment's going to terminate tomorrow. We'll give you your notice, your accrued holiday, and what we're going to do, just to make this super generous for you, £5,000 on top of all that. After this call, I'll let your colleagues know that you won't be coming back. They'll keep this confidential, and if you can keep it confidential as well until you've signed up to the agreement, that would be good. We'll give you a reference. And you just need to get some legal advice as well. So what we've done, just to give you some help here, make it a little bit less painful for you, is we've got a solicitor that we normally use for these sorts of things. I've already contacted them, and they've got a slot at 5 o'clock. So if you give them a call, you can go and see them at 5 today and get it signed. So, we should be able to get this sorted pretty quickly. But please do keep this as confidential. Now, I appreciate you're perhaps a little bit concerned about the conversation we're having at the moment. So, you don't have to go back to work today. So take some time off and prepare for your 5 o'clock call. And then once you've appointed your lawyer, let me know. If you've got any queries, then come straight to me. But in the meantime, Adam, any questions?
What's happening? I've got a meeting with Sally in half an hour. What am I doing?
Sally? I wouldn't worry about that.
Team meeting.
We've already cancelled that for you.
Right, so I leave now.
I think that's probably best. Yeah. Yeah, so yeah, hopefully by tomorrow we've got it all sorted.
Right.
Thanks, Adam.
Okay, thanks. Okay. Right. Well, that was an interesting exercise in being on the other side of the table. So some learning points around that one. Few things to bring out. I think hopefully you all agree with me that Rebecca as manager was being quite heavy-handed with me there in the approach, and didn't really have much opportunity to reflect or take time to understand what was going on, or and it was certainly made pretty clear that there weren't really any other options. But if we pick through the issues of without prejudice, because that was the labeling and the format that the manager had chosen for this one, it was pretty clear from the start of the conversation, wasn't it, that at least on the face of it, the employee didn't have any expectation that there was a dispute. Thought that COVID was probably why he didn't get a bonus. Didn't really think he'd been poorly performing. There's a very real issue here and risk around whether at the point that this discussion is being had, there was a dispute from which without prejudice protection could apply. That calls into question whether any of that discussion is actually off the record in the sense of not being disclosable later. I think also another problem was the employee was so stunned into silence that there was the manager almost agreed with themselves that this would be a without prejudice conversation. I don't think the employee at any point said, yes, okay, I'd like to have one. And that is another risk. It's a common angle that's, as Rebecca pointed to earlier, that lawyers are getting more and more cute in advising employees on this, that that's going to be a potential issue because the lawyer may say, well, you thought you were having a without prejudice conversation. At no point did the employee agree to that. So anything you discuss with them wasn't on a without prejudice basis. That wasn't what was agreed, and they can refer to it later. More generally, there was a sense of ultimatum, wasn't there? Really, there was no indication there is another process or option at play, and that has a number of impacts because, of course, the employee doesn't have to accept this offer. And from one perspective, you'd say they will be aware that the employer is not setting up and planning a proper process to do something about them in a way that will be fair and appropriate if they don't do a deal. The manager didn't set out a good legitimate process or set of steps that will be taken if I'm not interested in the deal. And it also just goes towards this kind of argument that it was improper the way it was done, in that it was kind of, you're leaving anyway. This is just your chance to get a better deal than us just kicking you out unceremoniously. The other point that goes towards that thing of there isn't a plan B, so me as the employee thinks they've got to do a deal with me and I'll ask for more, was that there's already a settlement agreement, 25-page document, been drafted. So that tells me as the employee that the employer spent time and money on this, and one way or another, they're committed to that being the outcome. And I'm going to use that as a basis to say, well, if you want that to be the outcome, you're going to have to do a bit better on the numbers, because I think you haven't got a plan B. And if your plan B is just to sack me tomorrow, I'm going to have a claim. And that probably leads to the final point I'd make. Well, there's one point around, did anybody pick up on the point about the solicitor? It was the solicitor that we normally use, was the way the manager put it. So from a settlement agreement perspective, doesn't sound like an independent advisor. That would undermine the validity of the settlement if the advice was taken from them. But on the final point I'd make is that whether or not the protection of without prejudice applies to this discussion, it's a point I made earlier, these words can't be taken back. And the employee now knows exactly where he stands and what the employer and the manager's position is. And if he doesn't want to do a deal, or you can't reach an agreement on the settlement, you may well have just entrenched him in a position that he will doggedly stick to now of, I'm going to sue these guys, come what may. And I'm going to argue I can tell the tribunal what's just been said, on the basis that even if I can't tell the tribunal, I know they're stitching me up and they're going to sack me whatever happens. So unless they make this worth my while, I'm going to go to the tribunal with the full force that I can, whether I get lawyers or not. And so that is the point I made about, it doesn't, quite apart from whether there's privilege, protection or whatever else, it may have started the employee down a path that is going to have big ripples later on. Good.
Thanks, Adam. We've got a couple of questions that have come through on the back of that. One is, what happens if an employee refuses to actually accept that without prejudice or pre-termination negotiation conversation? It is fairly rare that they do refuse, but if they do say, sorry, but I'm not prepared to have that meeting, then our advice is usually actually stop at that stage and consider what your next course of action is going to be. And that may have to be, going down a more formal route, be it a formal route of perhaps redundancy consultation, a formal route of disciplinary proceedings, if there are some conduct issues there. But yeah, I mean, it's not advisable to just plough on if an employee has specifically said, I don't want to have this conversation. So don't do that. And then the other conversation was, the other query was around the note-taking in those meetings as well. So, should you keep a note of the fact that the employee has agreed to that without prejudice conversation or protected PTN? And absolutely keep the notes, because it may become an issue that is in dispute at a potential tribunal, where the tribunal's having to determine whether a document is admissible or not. The employment judge would then see your notes where the employee has agreed for that conversation to be a PTN or potentially without prejudice conversation. And on that basis, the employment judge would say, well, we're not letting that document come into the sort of open court proceedings. So yeah, absolutely keep a note.
I would agree with that, and obviously mark the note very clearly as being a without prejudice record. It's a without prejudice at the top in bold.
Yeah.
And as you say, Rebecca, it's for you as an accurate record as the employer of what you said and what the employee said to evidence that there was a without prejudice discussion and agreement over that. And yeah, on the first question, it is that point about, I don't think I've ever recommended a client go into a PTN or without prejudice or any conversation like this without a plan B. You're so exposed. It's like that second case study we just looked at. If there's no plan B, then at any given juncture, you're left in a position where you haven't already thought through and aren't able to articulate what happens next, either because they say, no, I don't want to have a conversation, which, as Rebecca said, is rare, or the conversation just doesn't lead to agreement. What are you going to do next? And even if your plan B is, we're going to terminate and accept the risks associated with it, fine. But you have to have in mind and know what that's going to be, because it might not be that. It might be, we're going to instigate the capability process and hope that at stage X of that, the person will come back to the table and be in a better position to then accept a settlement. Yeah,
no, absolutely. Any questions that we don't get time to answer, because time is actually sort of ticking on in this, we will come back to you and we'll put our questions, as we always do, that we've received onto the website with the recording of the webinar as well. So apologies if we don't answer everything during today's live session. But I want to move now on to confidential and privileged documents. So Adam's concentrated on the conversations. I'm going to look a little bit more at the actual documents. And as we were saying about, the notes of the meeting, the documents will become important and will become more important if you obviously don't settle following a without prejudice discussion or a PTN. But a lot of people think that just because a document is marked confidential, it won't be subject to disclosure in a future tribunal or court proceedings. Now, that's not the case at all. If a document has protection from being admitted to the tribunal, that needs to be protection either in the form of without prejudice documents, documents in the PTN discussions, or there is another category where documents can attract what we call privilege. And privileged documents you will be able to keep from the eyes of the tribunal, and perhaps most importantly, from the eyes of the other side, so to speak, if there is a contested matter. But don't fall into the trap of just thinking that because you mark a document confidential, it will then automatically gain privileged status, because there are some fairly set rules around when a document does attract and fall within the scope of privilege. Obviously, you know, as Adam said before, the employer often, sometimes the employee, you know, they want the freedom to have open and frank conversations about resolving issues, but not every confidential conversation you have will allow you to have those open and frank discussions. So you've got to, you know, you've got to really consider this before you start either emailing an employee or having conversations with an employee. The two main types of privilege that I'll be talking about are what we call legal advice privilege and litigation privilege, that can attract itself to your documents. And we all know that tribunals can be won and lost on the basis of really unhelpful documents. Now, sometimes those documents might go into the tribunal bundle and they didn't actually need to go in the tribunal bundle, but it won't be known by whoever's putting that bundle together that a document could actually have been withheld because it did have that privileged status. So, you know, it's something that is really important to understand as to what has to be disclosed and what can be kept out. So just moving on to the next slide, what has to be disclosed to the tribunal? Well, unless a document is privileged or it has the without prejudice or the PTN cloak of protection that Adam's discussed, then pretty much anything that you're passing internally within your organisation before litigation is contemplated will have to be disclosed in a tribunal. So that includes your early drafts of documents before any dispute, before any litigation is contemplated. And that might include things like redundancy projections, draft termination letters, and all of those horrific internal emails that you probably get that you wished you hadn't got because the managers have written things that you really wish that they hadn't written. All of those documents become fair game for disclosure within the tribunal. That's when we tend to have our really difficult conversations with our clients, when the disclosure process kicks off, because we see perhaps, you know, a difficult document that can completely change the strategy of the tribunal and the merits of a case, and that can then feed in quite quickly to a change of approach, i.e. settlement, if there is a you know, a rogue and unhelpful document. If that document, however, has attracted privilege, we can breathe a sigh of relief, because actually that will be for our eyes only. So just moving on to the next slide, being a bit like Chris Whitty here, but privilege in communications. Once privilege has been established, it can be withheld from production to a third party. So that's the other side, the tribunal or anybody else that is asking for it, aside for some, you know, some sort of perhaps issues regarding sort of regulators who may be able to sort of get through the cloak of privileged. And even if that privileged document is so relevant to the tribunal and would actually, you know, sort of make the other side's case perhaps a slam dunk case, it's of no consequence if it is a privileged document. So that's why it's so important to understand when a document can be privileged and when it won't be. Now, from a tribunal perspective, there's a general court rule that you are entitled to withhold inspection of privileged documents, but technically you're meant to include the description of those documents in a list of documents. So not the content, but just what documents you are actually holding. Now, the tribunal accepts that really anything created in connection with the preparation of a party's case is going to be privileged, and it's very rare that we need to do a two lists of documents, one with the non-privileged documents and one with the privileged documents set out. The tribunal just don't expect us to do that, although technically it is something that, you know, could be insisted on. But, you know, the tribunal will accept that, you know, there are things that are created in the preparation of a case that are going to be privileged, and those are documents created on a without prejudice basis with a view to settlement. Those are exchanges with ACAS. Those are correspondence between the client and the lawyer. Those are notes of interviews, perhaps with witnesses, and, you know, all the without prejudice correspondence that you will have engaged with. Now, the two types of privilege, or the two main types of privilege, because actually lawyers being lawyers create lots of different subsets of privilege, but the main types of privilege that we see are legal advice privilege and then what we call litigation privilege. So just moving on to legal advice privilege, that is there to underpin the principle that a client should have and should be able to place complete unrestricted confidence in their lawyer in respect of the fact that the communications that they're having with their lawyer will not be disclosed outside of that lawyer and client confidential communication discussion. Now, legal advice privilege, and I mention the word confidential because it actually does only apply to confidential communications, although, you know, you'd be hard pressed to think what conversations between lawyer and client are not confidential, but it is something that applies to confidential communications passing between the client and the client's lawyer. But it also needs to include something else. Those communications need to have come into existence for the purpose of giving or receiving legal advice about what should be done in a relevant legal context. So if the lawyer and the client were having communications about a non-legal matter, then actually those conversations don't attract legal advice privilege. So, you know, lawyers do tend to give sometimes more commercial, business-focused advice as opposed to strictly legal advice. And arguably, those types of conversations, those types of documents would not then attract legal advice privilege. They might attract litigation privilege, which I'll come on to in a minute. So where proceedings have actually been issued or contemplated, but if it's well before then and, you know, business advice is being given, we cannot say to you with 100% guarantee if we're giving, you know, non-legal advice that somebody isn't going to, you know, insist that we disclose information. Now, once communications are privileged, that privilege applies for all times unless privilege is what we call waived or lost. Privilege might be waived because actually it's quite useful to rely on that lawyer-client information document for some reason. It might be lost, however. You know, there might have been a document that's been put into the bundle and it's too late then to sort of whip it out once lawyers are instructed, or sorry, once the mistake has been made, and the privilege can be inadvertently lost. So again, be careful about where you're sending documents, and if you are wanting to waive privilege, it's usually waiving privilege, not just in that document, but if there is a context to that document, it might be documents or emails that are perhaps either side of that particular one that you do want to waive. So there's quite a complex decision making on whether you're going to waive privilege. So just moving on to the next slide as well, and just sort of reiterating, it really is a case that it is in relation to only client and lawyer conversations, only communications and documents regarding obtaining legal advice. And I've said it doesn't attach to communications with third parties, and I'll do a prior apology to the HR consultants that are participating in the webinar, but legal advice privilege unfortunately doesn't attract itself to communications with HR consultants and potentially their clients, or indeed with the lawyer and HR consultant, unless the HR consultant is the client, or unless we're corresponding with the HR consultant and the client potentially at the same time. Now, what you also need to take care of is when you receive legal advice from us, that you don't start passing it around sort of on a fairly wide basis internally, because what is a client is something that isn't meant to mean a client is anyone in that organisation that has received the legal advice. A client will be those employees authorised by that company to communicate with the lawyers on behalf of the company. So if you get an advice from us and you start sending it around to lots of different people, then they aren't necessarily our client, and that could actually then mean that that document is no longer privileged. So be very, very careful about what you do with our legal advice and where you send it. Moving on to the next slide, and the next subset of privilege is something called litigation privilege. Now, litigation privilege is, as you probably would expect from the title, when litigation is effectively in play, or if it's not in play in terms of it's not existing, it's actually pending. So pending might be that the first contact with ACAS has been made in respect of early claim conciliation. Reasonably contemplated might be because you've received a letter before action. So those are probably things where they're pending or reasonably contemplated litigation. But for litigation privilege to apply, the documents must be communication between the lawyer and the client, or they can be between either of them and a third party. So actually litigation privilege is wider in respect of the scope of the people who are involved in the communications. Again, perhaps more for the HR consultants on the call, it is accepted that litigation privilege extends to HR consultants, who may be acting in tribunal proceedings or, pending or contemplated tribunal proceedings. They will be able to use in a lot of cases litigation privilege in respect of some of the documents that they may well be involved with. So just finishing up, a couple of tips to maintain privilege. So whilst we don't necessarily want to be copied in on absolutely every single document, there might be some key documents where actually it is a good idea to keep us copied in, keep your legal advisor copied in to maintain privilege of some key documents, where those documents, we need to see them for the purposes of being aware of the legal advice that we might need to give. Restrict privileged documents on a need-to-know basis, and do instruct, if you're sending it on to somebody in your organisation, do make sure that that recipient then doesn't go rogue and starts forwarding it to lots of other people. So do think very carefully about your circulation. Think really careful about email chains, because, I don't know, sometimes you find the horror of legal advice and privileged information in an email chain that's then sent on to people that you wouldn't necessarily want it sent on to. So sort of keep your email chains in check, and start a new email effectively if you're concerned that something 6 pages down in the email might be privileged. And as I say, remind recipients if they receive privileged information that it is confidential, it is privileged, you can mark it as that, and that they shouldn't be forwarding it on without any further permission or guidance. And then just some tips in respect of disclosure issues as well within the tribunal process. So disclosure isn't only damaging just in tribunal proceedings, it can also be damaging in subject access requests, DSARs. So always be careful about what you are going to be disclosing. The requirement to disclose documents following the receipt of a DSAR request, subject access request, is very similar to the requirements to disclose documents in a tribunal setting, in that you can still rely on legal advice privilege and litigation privilege. So, you know, you don't need to put into a DSAR request legal advice privilege and litigation privilege documents. What we tend to find with employers who respond to DSARs is that sometimes they then get themselves in trouble, because at the tribunal stage, where there is a court requirement to disclose documents, the smart employee or the smart employee's lawyer will look at the DSAR documents, they'll look at the tribunal documents, and if they're not the same or incredibly similar, that will probably be an attack on your credibility. So the DSAR response might have been a bit light, but in the tribunal you think, well, this is a court proceeding, so I need to actually disclose more. And you know, you could end up in a situation where you then get a complaint from the ICA because you've had you're in a position with an incomplete DSAR. So remember privilege issues at the DSAR stage, and not just at the tribunal stage. We do tend to say to people, if you think there's an issue arising, try and keep written correspondence to a minimum. You know, we don't really want to be arguing about whether a document's privileged, it should be admitted or not. Limit recipients of documents to those who need to know. Avoid lengthy email chains. And probably the best piece of advice is, you know, start from the position you don't want to put anything into writing. You wouldn't want a judge or the employee or, you know, the other side's solicitor knowing and reading. So there's a lot more on disclosure we can do, but those are sort of just some issues on privilege and confidential documents and disclosure issues in the tribunal. Now, our next session is going to be continuing with your how not to lose. And before we tell you the specific sort of subtopic of that, we just want to ask you, how many of you have received notification from your employees in the last 6 months that, or received notification from ACAS that your employees have commenced the ACAS early claim conciliation? So I'll just give you a minute to answer that. Okay. That is quite a worrying amount, actually. 36% of you, so over a third of you, will probably be expecting to be involved in some sort of tribunal proceedings in the next few months, which ties in very nicely with what our next webinar will be. So on the 19th of November, we are going to be looking at what happens when you receive that initial contact from ACAS to say that early claim conciliation has started. So we'll be talking through how that process works, practical steps you can take in relation to that process, what happens when early claim conciliation fails and you then have to respond to the ET claim, and the options then available to you. So we've run over a little bit, but hopefully you found it useful, and we hope to see as many of you as possible at our next session on the 19th of November. So have a good day, everybody. Thank you.